Hello, my name is attorney Wendy Guthro, and today I am presenting on the intersection of estate planning and divorce. I'm going to start my screen share with a presentation a PowerPoint presentation that we can walk through together. So the intersection of divorce and estate planning is really summed up with the series of leaves here that there are changes that take place in many parts of your life, emotionally, mentally, legally, that we have to just try to stay in step with the changes that are taking place. And that is what this presentation is here to help you do, to stay in step with the legal changes that are coming your way. As I said, my name is attorney Wendy Guthro. I'm a licensed practitioner in Massachusetts and in New Hampshire, primarily focusing on estate planning, elder law, probate, and trust administration. And I'm a member of the National Academy of Elder Law Attorneys with admissions, as noted there. The objective of this presentation is for you to understand the importance of updating your estate plan after a divorce, and then the steps to take to do that. Why update your plan? You want to ensure that your assets are distributed as you wish. That is one of the main reasons why people who are divorced want to make sure that they make these changes. You want to select individuals to make health and financial decisions for you, especially when you can't make them for yourself. And you want to reflect your new life with your legal decisions that match your intent. An overview of this presentation. It's a 7-step process to revise your estate plan after divorce. You need to update your will. You need to change your beneficiaries on assets. You need to change your power of attorney so that your ex-spouse no longer is in the first position to have control of your finances. You should update your healthcare documents. You should revise your trust if you have one. You should select guardians for minor children, and that you should review jointly titled assets. We're going to take each one of these steps one by one. Here's a graphic depiction of the primary corner estate planning documents that most of my clients have in their estate plan: a will, a trust, a durable power of attorney that handles your finances, and the bottom row, those 3 documents are all healthcare documents: healthcare, HIPAA, and advance directive. And I bring those 6 documents to your attention because you need to update your estate plan upon a divorce. And these are the 6 documents that you should update: your will, the revocable living trust, the durable power of attorney, and then those 3 healthcare documents. We're going to start with step 1, updating your will. What is a will? It's a legal document that distributes your assets after you pass away to the new owner using the probate court system. And the will only comes into fruition upon your passing. It's not a document that can be used during your lifetime. Conversely, a trust that we'll get into shortly is a document that can be used during your lifetime. But a will is only used upon your passing, and this is one of the documents that you do want to change and update your will. You want to update it so you can change the inheritance details. Your surviving ex-spouse should no longer normally be a recipient of your estate. You want to choose a new personal representative to be in charge. That used to be called the executor, executrix, or administrator or administratrix, now referred to in totality as the personal representative of your estate. And you want to remove your ex-spouse from your will as a fiduciary and a beneficiary. A fiduciary would be your personal representative. A beneficiary would be the person who receives your inheritance. Step 2, you want to change beneficiaries. You want to change beneficiaries to update, to remove your ex-spouse. You want to choose new beneficiaries or name your trust if you have one on bank accounts, investment accounts, life insurance policies, a 401k, an IRA, any retirement assets, annuities, retirement and non-retirement annuities, savings bonds, stock certificates. All of these assets usually have a beneficiary designation form associated with them. And that beneficiary designation form needs to be changed to remove your ex-spouse and put in new named beneficiaries. Step 3, You want to change or at least review your power of attorney. A power of attorney is a document that allows you to appoint someone you trust emphatically to manage your finances during your incapacity or in your capacity. So whether or not you have capacity or not, this document can be written two different ways. But usually, when you're married, we would appoint a spouse as your attorney in fact or your agent under your power of attorney. So you want to appoint new people to make financial decisions for you, and you want to revoke an old power of attorney and put a new one in place at every financial institution where you have put your previous power of attorney. Step 4, you want to update all of your healthcare documents. The three healthcare documents that I've already alluded to are your healthcare proxy, your HIPAA, and your advance directive, also referred to as a living will. Your healthcare proxy and your HIPAA, you normally want to remove your ex-spouse from this role because that is the person that's going to actually be making healthcare decisions for you when you are not able to make them for yourself. You want to choose new individuals to make medical and end of life care decisions for you. Your healthcare proxy gives a designated person the authority to make healthcare decisions on your behalf, but only when you lack capacity to make your own decisions. That person is referred to as your healthcare proxy or your agent. So if your ex-spouse was your agent, you'll need to choose someone else to make these decisions for you. The last two healthcare documents are your HIPAA and your advance directive. Your HIPAA can name a group of people who have access to your protected medical information and to be able to obtain information about your medical status from medical institutions such as hospitals or doctors' offices. And the advance directive determines if you wish to be kept alive on life support. And sometimes that document names a person to implement your wishes. So, in most cases, you need to get a new HIPAA and an advance directive to remove your ex spouse so they do not have access to your medical information or status, and that they have no authority over your end of life care. I would like to mention that in all of the documents that I am referencing and seeking to remove your ex spouse, there are some divorces where an ex spouse is get along, go along, and that you still want them involved in your plan if it was an amicable divorce and that you're raising children together and that there isn't any reason why you wouldn't maybe want your ex spouse to still play a key role in your estate plan. But this presentation is primarily based upon when you do not have that relationship with your ex-spouse. So we are trying to extract them from all important fiduciary roles and as a beneficiary from your estate, and that you would name other people to take their place. Step 5, revise your trust. Primarily, we're referring to a revocable living trust. And a revocable living trust is a legal entity that can hold your assets for your use during your lifetime and distribute assets after your passing to new beneficiaries other than yourself without using the probate court system. So a trust is simply a container to hold things. You would normally put your assets in this trust. And that if you have a revocable living trust, you do need to put some attention to this document after a divorce. So what you want to do when you revise your trust is that you want to terminate any joint revocable trusts. You want to create an individual revocable trust for yourself. You want to transfer any deeds that are now titled in your own name into your individual trust. You want to update trustees and beneficiaries and remove your ex-spouse from controlling minor children's sub-trusts that might be embedded in your current trust. Should you change the trust? Well, you need to look at the terms of the trust that might want to be changed, the trustees who's in charge, and the beneficiaries. And so here's a graphic depiction of a revocable living trust that is funded with a deed, your personal property, your bank account CDs, your savings bonds, and that previously you and your ex-spouse were the grantors, and the two of you were likely the trustees and the beneficiaries, and that you had control of this. So now what we want to do is possibly change the terms of the trust so that we are not naming sub-trust to be created possibly for the benefit of an ex-spouse. We are going to change the trustees so that just that you are the trustee possibly, or you and one of your children, or another person you trust emphatically. And you want to remove your spouse as a beneficiary of the trust. Step 6 is consider guardianship. This pertains to minor children as well as if you have any adult disabled individuals that you are their guardians, and maybe your ex-spouse was as well. So you maybe want to petition the court to make some changes to that. But for minor children, decide who will be guardians of your minor children. If your ex-spouse is guardian, which is common, you might want to select successor guardians, that if your ex-spouse predeceases you and then you pass away, that let's make sure that we have a succession plan in place for your minor children. So you want to update your will, your trust, your guardianship documents, if you have those specifically, with these selections. Step 7 is you want to review jointly titled assets. You want to close joint accounts, open up individual accounts, open new individual accounts, and then also name a beneficiary. Normally it would be a child, or get car titles, or excuse me, or transfer those properties into a trust, as I've noted in the fourth bullet. You want to get car titles in your individual name. So if you and your spouse owned cars together, get them titled in your individual name. That can normally be done online at the Registry of Motor Vehicle. And then you want to transfer property ownership via new deeds to you individually or to your new revocable individual living trust. Those were the completion of the 7 steps. So what is your action plan or your action goal first at this point? It is to update your estate and your financial plans for peace of mind. You want to make sure your wishes are legally binding, that if you want your ex-spouse written out of your estate plan, then we need to put that into action from a legal perspective by changing your estate planning documents and your financial documents. And we want to select new fiduciaries immediately to make healthcare and financial decisions for you in the event of your incapacity. This is not something that you want to wait on. You want to do this immediately. So your action plan is to notify your attorney and financial advisors. Inform them about your divorce so that they can help you put together a plan to update your documents and your accounts. And we want to ensure that all changes are legally binding to remove your ex-spouse as a beneficiary of your assets. So the summary of this presentation is the 7 steps that we had said to revise your estate plan. You need to update your will, change beneficiaries, change your power of attorney, update your healthcare documents so that your ex-spouse isn't in charge of making healthcare decisions for you, revise your trust from the trust terms perspective, from trusteeship, and as a beneficiary, and as a trustee for any trust created for your minor children, or for any of your children for that fact. Select guardians for minors or for disabled adults, and review your jointly titled assets to make sure that they won't pass by operation of law to your ex-spouse, who may still be a joint title owner on those assets with you. Specifically, from a lawyer perspective, estate planning documents to change after a divorce would be your will, your revocable living trust, durable power of attorney for finances, your healthcare proxy, HIPAA, and your advance directive, those 3 healthcare documents. Some common questions that I get regarding divorce and estate planning. Does divorce revoke a will in Massachusetts? In Massachusetts, a divorce revokes all bequests in a person's will to an ex-spouse. So it doesn't revoke the whole will, just the specific bequest to an ex-spouse. And all fiduciary appointments in the will in favor of the ex-spouse, including the nomination of them as a personal representative. So if you don't get to do this before you pass away, that there are laws in place to accommodate this. But if you're going to be using the probate process for this, and you're submitting the will that says that your ex-spouse is your personal representative, then probate becomes a little bit more difficult because now you have to provide divorce decrees to show that you are no longer married. You have to create affidavits, and you now need to submit those with the will to the probate court, along with the successor appointment of a personal representative. Question 2, does divorce revoke a power of attorney in Massachusetts? That is the document that you appoint a fiduciary to make all financial decisions for you during your incapacity as well as your capacity, if you wish. So it depends what the document itself says, but in general, an agent's power pursuant to a durable power of attorney is revoked upon divorce, but not on a judgment of separation. So that you do have that interim period from the time you separate to the time that you get through the final divorce decree and through the NISI period of a divorce, and that you can, during that period, remove your soon to be ex-spouse and ex-spouse as your attorney, in fact, under your power of attorney, your agent. So we highly recommend that you do this during this time period, since you don't have complete separation of having your spouse and ex-spouse to be in charge of your finances under your durable power of attorney. If divorce generally revokes a power of attorney in Massachusetts, why revise it? Just as I had said, because a power of attorney is a powerful financial document that you want to immediately revoke and replace it at all financial institutions to alert them that your ex-spouse no longer has access to your assets. So you should designate new agents immediately. And then you want to go to each financial institution where you put your power of attorney, ask them for that power of attorney back because you are revoking it. Sometimes you need to do that in writing. And then you need to supersede it with your new power of attorney. And your new power of attorney should say that this power of attorney revokes all previous powers of attorney. Fourth and final question. If I forgot to remove my ex-spouse as a beneficiary of my retirement assets and life insurance policies, will my named successor beneficiaries take it instead? Because you're divorced and that happens with some other assets. But no, you must complete new beneficiary designation forms on each one of these assets, naming whom you wish to receive these assets now upon your passing. So these are critical. And sometimes these cannot be done until a divorce decree issues, but oftentimes these can be done immediately, especially when it comes to your life insurance policies. Although some divorce decrees, I've seen that a spouse needs to keep an insurance policy active even post-divorce for a certain number of years, and you need to provide evidence and annual renewal evidence of the policies. So, but for situations like that, you do want to actively and affirmatively remove your ex-spouse as the named beneficiary on all retirement assets and insurance policies. So that wraps up our questions. So thank you very much for watching this presentation of divorce and estate planning. You can contact our office if you would like us to send you a summary of this presentation. And in addition, if you have any questions, you can always reach out to our office for your estate planning needs at guthrolaw.com. Our email is office@guthrolaw.com. And you can always call us at 781-229-0555. Our website does have a lot of videos under our video resources tab that goes into basic estate planning, probate, estate administration, Medicaid planning. So if you have any interests above and beyond the divorce and estate planning, you're more than welcome to visit our website. Thank you very much for joining us today for this presentation, and hope to see you soon. Thank you.
If you would like help or have questions about this information, please give us a call at 781-229-0555 or visit our website at guthrolaw.com. We look forward to hearing from you.